Welcome to Q&A practice. Let's start with the plaintiff attorney. Ready? Was it the 1999 product year or was it 1998? I don't know for sure. Okay, and who is Mr. Sanchez? He's the director of R&D. And is he employed by Ryder North China? Yes, but his email address indicates Ryder North Limited. Is that fair? Yes. Why would that be if he was employed by Ryder North China, if you know? I have no idea. Maybe that's the only email address they had at the time. Okay, I direct your attention to the second page, which is FO 30241, and there's a line that says FYI, comma, following canopies are selling in Walmart stores. Do you see where I am? Yes. And the third product listed, which is listed as retailing at $92.51, was a 10 by 10 canopy manufactured by Wilton. Is that fair? Yes. And then the fourth product listed, which was retailing at $325, is a 10 by 10 canopy with lights. Do you see where I am? Yes. Do you understand? That is manufactured and sold by Wilton? I do now. Okay, so at least as of May 2001, Ryder North was aware of the products sold by Wilton. Is that fair? Based on this email, yeah. Why don't we take a short break? How long? 10 minutes. Fair enough. That's fine. Let's go off the record. Back on the record. Steve, before we took our break, we were talking about, among other things, deposition exhibits 12 and 13, which are the patents, 2 out of the 3 patents, which listed Richard Ryan and Ron Kang as the inventors. Correct. And if we covered this before, I apologize. Are either of them still, well, let me just do it this way. Is Mr. Ryan still an employee of Ryder North US? No. And is Mr. Kang an employee of Ryder North China? No. Now, we had also talked about Deposition Exhibit 14, which is the email from May of 1999, which identified a couple of products produced by Wilton. Is that a fair statement? Yes. Do you know whether, in developing the products at issue in this case, anybody at Ryder North used as a model a Wilton product? I don't personally know. Who would know? I'm not sure. Would there be anybody at Ryder North US who would have such knowledge? Not that I can recall. How about at Ryder North China? I'm not sure. How about at Ryder North Limited? I'm not sure. Did you make any inquiries in preparation for this deposition to try to determine the answer to that question? No, I don't believe I did. And would you agree with me that during the development of the Ryder North products that are at issue in this case, employees at Ryder North US were involved in that development? I can't tell if anybody was on the US side was involved in the development of the product. And are you saying you can't tell just based solely on Deposition Exhibit 4 or more generally? Well, specifically on 14, I can't tell whose, if anybody's, responsible for development of the product. Okay, and my question then is a more general one. Do you know whether generally, let me back up, do you know as a general matter whether anybody at Ryder North US was involved in the development of the Ryder North products that are at issue in this case? No, I don't personally know. And you understand that you are the representative designated to testify on behalf of Ryder North US here today? Correct. And in that capacity, you also don't know. Is that correct? Repeat the question. In your capacity as the designated representative on behalf of Ryder North, to testify here today, you don't know whether anybody at Ryder North US was involved in the design and or manufacture of the products that are at issue in this case? Well, objection, compound question. You can go ahead and answer. As far as I know, design is done overseas, so I don't know who has been responsible for design in the U.S. So you just don't know if anybody was? No, I can't recall. Let's do some practice now from our other transcript. All right, ready? We'll make a relevance objection. Okay, well, I think that generally it's understood that a 48 license has some value for some, and maybe more value than other types of licenses. However, it is not really relevant what that value might be as far as in exact dollars, so I am going to sustain the objection, indicating that it's not relevant to the issues to be determined here. All right, so the respondent rests. Yes. Did the department have anything other than closing at this time? No, I think we're ready for closing. All right, I'll hear the department's closing then. Thank you, Your Honor. For this matter, I know it's been a little bit of a long day, but we contend to you that the counts in the accusation have been sustained, and that, as Mr. Crane already alluded, the appropriate resolution of this matter is that the license be revoked. I know the court has taken its own notes, but just to kind of highlight things that we have here, what we have here is, you know, an investigation that took, let's say, from May 29 of 2004, and it ends in November, so 6 months. And as you recall, in one of those, there was about a month break between the visits, and on some of the instances, in contrast to a month's break, the investigator went 2 times on the same day. And basically for each of those visits, as they've come into the totality, Investigator Jones was able to purchase cocaine in one form or another from various people in the premises, not only from Linda Conroy, as he did on 3 occasions, but he was also able to purchase from other people, namely Ron Diaz, and I believe that there was Juan Castillo. That's right, he didn't sell as many, and that's all of these transactions are happening. Now, some happened in the men's room, but others happened in plain sight, and in plain sight of several of the bartenders, and this also occurs in the context of where there's ongoing discussion, maybe not in the beginning transaction, but as Mr. Jones discussed with various of the bartenders. I want to buy something. Can you hook me up? Can you help me? And in some instances, they were able to just make the connection for him and sell it to him directly, as Ms. Conroy did, or were there when these transactions occur. And I think that in this instance, and especially because it involves all these, it's not just one person who's doing this. This is like a whole combination of events, and including, you know, several of the bartenders openly discussing their own narcotics use, transactions right in front of them, and they participated in them themselves, and it goes over such a long period of time. This is not a one-time situation at the premises. Basically, what we have in defense is Mr. Kang, who's testified about his own personal health issues. But look, as it turns out, he basically said they don't really impede my management ability. I'm sure his medical conditions are of concern, but they didn't interfere with his management capacity, his overall management capacity of the premises. He was still able to visit the premises. Maybe he couldn't stay to the very end till 2 a.m., but he was but his medical conditions didn't otherwise interfere. He mentioned he has trouble getting around with his knees, but that occurred a few months ago, so that was not in play when all of these events were happening. He was only spotted once on one occasion by Investigator Jones, who was there these many times. And that will conclude our Q&A practice.